ask Attorney Del Campo to do a roll call so we can, first of all, can people hear me on the remote hearing?
Yes.
Yes.
Okay.
Yes.
Thank you, Your Honor. Justice McDonald is here. Judge Chaplin.
Here.
Judge Farley.
Here.
Judge Hernandez. Judge McLaughlin.
Here.
Judge Nueno Dowd.
Here.
Judge Pearson.
Here.
Judge Prats.
Here.
Judge Stewart.
I'm just going to need her for one of the agenda items. Okay, the first item on our agenda is the approval of the minutes from January 9th meeting. Is there a motion to approve?
So moved, Judge Prats.
The second, Judge Chaplin. Are there any changes or amendments to the minutes? I didn't see any. If not, all in favor, just say aye.
Aye. Aye.
Any in opposition? Should note that Judge Stewart is now with us, so she'll be marked in attendance.
I don't have an opposition, but I wasn't here last time, so I was just going to abstain.
Oh, okay. Judge McLaughlin, right? Can't see.
Yes.
There you go. Okay. So we'll have that noted for the record. I believe that we have Judge Pavia on, and she's taking time out of her day to address an item on our agenda, and I don't want to waste her time if we can take that up. Is there any objection if we take up the Sentencing Commission recommendation at this time? Is she with us? Is she on?
I am. Hi, how are you?
There
Thank
you
you.
Hi.
Thank you.
Your camera isn't on, but we can hear you.
Interesting. It's on for me. So let me try to go out and come
I
back
can
in.
see.
I can
Judge
see her.
Pavia.
Now I can't see her.
I can
Okay.
see her. Now can you see me?
Oh, there she is. Now we can see
Okay.
you.
Good. Hello,
Don't know what
everybody. Good afternoon.
Okay,
I-
so we're going to take that item up first. That's item 2023-001. It's a proposal to amend Practice Book Section 38-8 to expand the cash bail option. This is only our first time having it on the agenda, but I asked Judge Pavia to take some time out of her day as chair of the Sentencing Commission to give us some background on how this proposal came to be.
Thank you. I will also note that Alex Sarkoff, who is the executive director for the Sentencing Commission, is on, and he would be happy to answer any questions. And he has a lot of historical knowledge of this because he was around when the discussions of the first proposal went into effect. So ultimately, what we are asking for or submitting is to build on what was the 2019 proposal, which went into effect January of 2020. It basically added to or enhanced the 38-8 10% cash bond, which was already in the practice book. And what it did was it allowed for an automatic ability to post a 10% cash bond at the police department or also without judge's approval in certain circumstances. And those circumstances were for certain types of offenses where the bonds were $20,000 and under. Since the time that it went into effect, we have had some ability to track and look at some of the data. And what the data does seem to suggest is that it is being widely used. And used in a manner where 1 out of every 4, Alex, make sure you tell me if I'm wrong on my numbers. 1 out of every 4 people who fit the category, that is having bonds that are under the 20,000, have been able to take advantage of this and post those bonds at the police department, thus not having to wait and come into court to ask a judge at some later time, whether that means an overnight in jail or a weekend in jail or however that works. What we are noticing is that the 10% cash option is being utilized much more dramatically with bonds as they increase. So obviously, I'm sure you would anticipate that. But what we're seeing is that bonds that are 1,000 or under, 90% of the people who have those types of bonds are in fact taking advantage of the 10% cash option. That falls off dramatically when you hit a $10,000 bond where it's only about 41%. And then above that, from the 15 to 20,000, it's really only about 20%. 80% are then going to the traditional bond option through a bondsman or a bailsperson. And so what our proposal is to simply extend or enhance the ability to be able to use these 10% by increasing the bond amount to being 50,000 or under, and going from 10% to 7%. And the reason we chose the 7% was because that has traditionally been the amount that a bondsperson would be required to take, and therefore it would coincide with that more specifically. I will also note, and I think, Alex, I don't know if you have new statistics, but as of, I think, October, what they saw was that almost 4 million, I think $3.9 million had been returned to people who had posted these bonds. And so there is no, they're not seeing that there are more failures to appear in court. People are getting their money back. It's not just going to the bondsperson and then remaining there. And so all in all, we feel it's been a pretty successful opportunity for people to be able to post and not have to stay in jail any longer than they need to. I'm happy to answer any questions. Alex, did I miss anything that you want to add?
No, you described it perfectly.
Okay, let me, for members of the committee who may not be familiar with it, Judge Pavia, could you just explain the composition of the members of the commission so they can understand the array of participants in this process?
Thank you, absolutely. So the Sentencing Commission is made up of all types of stakeholders throughout the state, ranging from public defenders to state's attorneys to heads of every department. I think every department. I don't know if I'm missing anybody, but when we come together, it has representatives from a vast assortment, from DEMIS, excuse me, to victims advocate, to various entities, prison, pardons, parole, representatives from police departments, representatives from the defense bar. So it has really all of these people coming together and trying to work out solutions to various issues. In this particular situation, it was almost unopposed. There was one person who did not vote for it, but otherwise it was supported by everybody from all of the different groups that represent the Sentencing Commission.
And it's a large commission, isn't it? Like 25 people or something around there?
Alex, how many do we have right?
It's 23.
23.
And it's all outlined by statute. Each caucus of the legislature also has appointments to the commission.
Oh, thank you. I forgot that.
Both the chief state's attorney and the chief public defender are members of the commission, right?
They are. They
okay. are. So I don't know that any of the current members of the committee were on the committee when we did the 10% cash option a couple of years ago. But I learned at least that almost always the commission only will advance a proposal if it's I thought it was typically a vast consensus of the commission. I don't know if there are any written rules about thresholds for making proposals, or is that just an unwritten history of the commission, Judge?
I'm actually going to let Alex take this since I'm newer. I've been on probably about 8 months, but Alex could answer a historical question such as that.
We do have bylaws that the commission has adopted, and in the bylaws we do talk about a model of operating by consensus. And I would say that almost all of our proposals, not just to the Rules Committee, but to the legislature, have been either unanimously approved by the commission or have been near unanimous. We have very few contested votes.
Okay, and to either of you, I don't think that anybody from judicial operations is on the commission, is it?
I don't think so.
Okay,
I
so
don't know.
at a minimum, I think we probably want to populate this to them for their opinion, just to make sure that I don't imagine there'd be any difficulty implementing this, but what we normally do is, once we have this initial review, we think of institutional stakeholders in the legal community, a bar association, in the judicial branch, who might have some input on any unforeseen problems. This is a modification of an existing practice book section, so I don't anticipate it, but I could just want to make sure that the computer systems and that type of thing would be able to accommodate any such change. Are there any other, from members of the committee, are there any other stakeholders that you can think that we should solicit input from? Okay. So then why don't we do that? We'll hopefully get a pretty quick answer from operations about that, and we can take this up at our next committee meeting. Okay? All right. Thank you very much, Judge. Thank you very much, Alex.
Thank you for giving us the opportunity. If you have any questions, we're happy to answer them anytime.
Thank you.
Great. Thank you.
Bye-bye.
All right, we'll go back then the next item we're going to take up is 2021-023, proposal to amend practice book section 7-10, 7-11 regarding retention and destruction of summary process records. This is a oldie but a goodie that's come back to us. Can everybody, we've lost video for you. Can you still hear me though?
Yes.
Yes.
Okay. All right, as long as you can hear me, we'll figure out the technological problem, and then hopefully we'll be able to see everybody again. But my recollection was that we had tabled this some time ago in an effort to see if there was any renewed interest in the legislature to take up this issue. We had previously thought that it was at least a shared responsibility of the branch and the legislature as a public policy matter. So I don't know if Attorney Del Campo has any additional information. I have some, but not much.
We did try to determine whether or not the Housing Committee of the legislature was going to raise a bill that was similar to SB 200 last year. They do have a proposal.
Senator Looney did.
And that concerning fair share housing plans for municipalities and summary process action. So this appears to be the bill that they're raising this year.
Let me just say, this is actually just a proposal from Senate President Looney that's been referred to the Housing Committee. It covers 8 different topics, but the last of which says that it would require the removal of any judicial branch record of any summary process action after a reasonable time has elapsed. And this committee still would have to raise the bill, but if history is any guide, if the Senate President asks for it to happen, it'll probably get raised.
Justice McDonald, this is Attorney Joe Vonachey from Greater Hartford Legal Aid with some additional information, if you would like that at this time.
Great.
Hi,
Yes,
good
yes,
afternoon,
please.
everybody. So an act concerning summary process records, which was more in keeping with the SB 200 bill that Legal Services proposed last year, was raised on the January 17th Housing Committee meeting. And our understanding is it is with the Legislative Commissioner's Office. So it was raised on January 17th. It's been with LCO. We anticipate that it should be out soon, and there may be a public hearing at some point this month. And that's the most recent information that I have.
Oh, thank you. I looked before this meeting and I didn't see that any language had been released yet. So that's all I had was the proposal from Senator Looney. When that happens, could you please make sure that you get a copy of the legislation to Attorney Del Campo so that he can share it with members of this committee?
Will do. Absolutely.
Other than just monitoring what's happening in the legislature, there's nothing else that we need to take up at this time on this subject. Is that correct? Anybody have a different opinion? Okay. So we'll continue to monitor that. Once we have some substantial information, Attorney Del Campo will notify me and we'll put this back on another agenda.
Thank you.
The next item then is 2022-011, proposal to amend the practice book to eliminate the requirement for original to be printed on deposition transcripts and to permit service of civil complaints by consent. That last part is dropped off, so we're really just talking about the deposition transcripts.
Yes.
Attorney Del Campo?
Yes, this was on previously on January 9th. There were two options that were drafted for the committee to review. You had tabled it until this meeting such that you could review those options and that the Connecticut Reporters Association could review the options. Ms. Mannix, the president of that organization, has responded with comments about options 1 and 2, and that's what you have for consideration today. The various options that were available. Both options delete the requirement that an original sealed deposition transcript be delivered to the requesting attorney and then ultimately filed with the court, but they do things a little differently. One requests that some indicia of origin be placed on whatever transcript is ultimately presented to the attorney, whether it be watermark or some other indicia. And then the first option, I believe it is, just deletes fully the requirement that a original sealed transcript be prepared and then ultimately filed with the court. And this is in line with Judge Chaplin's suggestion at the January meeting. So that's what you have on before you.
Thank you. And recognizing that I haven't been in a courtroom of the Superior Court in about 10 years, I'm going to shut up and listen to those of you who do this more regularly about how you'd like to proceed, whether either option is preferable to members of the committee. Have I lost contact with everybody or nobody wants to speak up?
I'll take a crack at it. I read the last letter from the court reporters raising this issue, or addressing it, and saying, well, some lawyers are still asking for printed copies, so, what do we do? I don't know. I think, the court reporter's certification at the, back of the transcript is one way of authenticating the transcript. Sometimes they don't sign them, but I'm not sure, I don't think we want to create too much confusion out there about what the court reporters are supposed to be doing, and we seem to be doing that by requiring some indicia of origin on the pages of the transcript. So I don't know. I'm not. I prefer to have that, just because I know that 99.999% of the time it's not an issue, and most of our rules are designed to address those very few occasions when something goes wrong. But if there's ever a question about a deposition transcript between the parties, they can always go back to the court reporter and have that court reporter, verify which version of the transcript is correct. So I guess I'm leaning toward just eliminating that requirement.
Anybody else? I mean, my recollection of the origin of this was that the main component of the proposal was the service of the complaint by consent, which requires the legislature, and this was it seemed like it was a secondary issue. I don't know that there's any big groundswell. If members of the committee are not comfortable at this point, we could just table it for now and maybe revisit it when and if it becomes a more significant issue. I don't think there's any pressing need to move forward if people don't want to. Judge Stewart.
Let me just add one thought, and that is, first of all, with respect to the concern about people asking for originals, hard copy, I don't really think whether we change the rule or not, that matters. They can still get, their hard copy. I would point out, though, that we are doing so many of these remote proceedings now, and I would further point out that we're required, as I understand it, the appellate court now is only taking electronic exhibits. And although typically the deposition transcript is marked ID only, it's still an exhibit. So I would think it's more practical to have the electronic version with the watermark on it. Regardless of whether we have some groundswell or not, just as a practical matter for us, I don't really see the need to have the paper copy.
My only concern with that, Judge Stewart, in the notification from the court monitors, they just said the watermark will, some of the text you won't be able to read through. At least that's what I thought their letter said. And I know that at some point in time, we talked about just having the first page marked original, so that, to your point, Judge Stewart, I mean, I think in practice, many of us are utilizing, we're not having, they're not in front of us, and we're not having the grandiose ripping of the envelope. So, and I don't know why we couldn't, I didn't see anything in the court monitors with just a stamp on the first page saying original. And as Judge Farley points out, if the certification is there, I don't see why we need more than that.
I seem to recall, maybe people have better recollection, I seem to recall someone telling us at one point their software wouldn't let them just do it on the first page. Am I misremembering that?
This is Denise Mancini from the Connecticut Court Reporters Association. Standing in for Christine Mannix today because she's at a job. So I'm a little bit unfamiliar with the whole process here, but I think that their concern was that all court reporters have different types of software. So you can't universally say you can only watermark the first page because my software might do it, somebody else's software might not. As far as not being able to read through the text, I know on my software, you can change the lucidity of it so you can read through it, or you can just mark it at the bottom as a footer where you would normally see the reporting agency name. You don't necessarily have to have it across the page. So yes, I think in our minds we have this thought that you guys rip open the original transcript to make a big production of it, but I think in reality it's probably not that. So we were just concerned about what we should be doing as far as that goes. And if I may, as long as I have all you legal minds on here, we are also very up in the air, getting different versions from different people about remote swearing in. Some say we're allowed to do it by virtue of, Connecticut General Statute 1-24, blah, blah, blah. Others say we're not because the governor's order expired. So if anyone knows the answer to that, we have written into the Rules Committee. We have emailed the Rules Committee. We have asked many times for clarification on this. So if anybody can shed light on that, I would also appreciate it. Thank you.
Let's take one thing at a time. So I don't have strong feelings on this. It sounds like there is some interest in moving forward with some version of this. Do we want to just pick one of the two options that is before us for purposes of moving this forward to a public hearing in May, and it doesn't mean we can't revisit the subject at some point, but
So,
Jefflin?
if I may, I'll jump in since I started this flower sprouting up the ground. The issue, I think, has been kind of, we all agree that we want some indication on the digital copy, but the execution of that has become more of an issue for us. And I'm not sure that as a committee, our concern really is how it's executed. It's just more so that it is executed. And so with the different software, that's, I think, where the majority of our conversation in this bigger conversation. And I'm not sure that any of us really have a strong preference either way as to how it's done, as long as there's some indication of or on the digital copy. Does anyone disagree with that statement that I made?
If that's correct, I think it would militate a little bit in favor of option number 2, of the 2 options that have been presented to us. Do people agree with that? It creates the flexibility of having a watermark or any other appropriate indicia,
Yes.
would accommodate hopefully all of the different software that's out there.
Yes.
Okay.
Agreed.
All right, I'm just going to push forward then and say, is there a motion to approve this item with option number 2?
So moved.
Is there a second?
Second.
Okay, is there any discussion? Or we just want to vote? If there's no discussion, all in favor, say aye.
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 Is there any opposition or abstentions? That passes unanimously. Thank you, thank you. So that we don't have to revisit this again next month. And again, it will just be moving forward at this point for the public hearing in May. Oh, the remote swearing in. I have to tell you, I heard that the committee was emailed. I haven't seen that, and I wasn't aware of the problem. As you're mentioning it, doesn't surprise me at all that it's a problem. I'm sorry, it's Denise, right?
It's Denise, correct.
Do you know if your organization has any proposal before the Judiciary Committee for this?
No, I do not believe we do. There's someone on our committee that sent out, and I can probably look it up, but I don't want to waste anybody's time. You know, the Connecticut general statute that said the following people can swear in remotely under section, those under section such and such. And then that Connecticut statute listed Superior Court, Notary Public, town clerks, you know, and we're under that obviously as notaries. So some people were saying we're still able to swear in remotely. And then some people were of the voice that once the governor's proposal or whatever ended, executive order, thank you, ended, that no longer provided us that option. So some reporters are having the attorney swear the witness in as an officer of the court. Some reporters are swearing them in under that statute. So we're just unclear, and we'd like to be, you know, consistent with what we're doing. So.
I appreciate that, and I can understand that. You know what I would recommend at this juncture, at least as a next step, is that you talk to Attorney Del Campo, and that between the two of you, you talk with Melissa Farley about whether or not there is any opportunity to include something like this, some clarifying language in the court operations bill that is annually submitted by the branch to the legislature for their consideration. It's kind of an omnibus operating mechanisms type legislation, and see if that is an available option. I don't know how that gets put together within the judicial branch, but is that an option, Joe?
Well, I will just tell the committee that you haven't seen this. I have seen it, either as counsel to this committee or as director of legal services. I mean, originally we saw a lot of questions of this nature, trying to figure out how the court procedure, having been suspended, relate to the executive orders. And we've not been inclined to give out that kind of legal advice. I mean, people go to the governor's office to figure out what the EO's effect is or no effect. I mean, we did get this early on from Ms. Mannix in terms of just a general question. It had come in again attached to the back end of this proposal. It has not been presented as something that I could give this committee yet.
Right.
So that's why you haven't seen it, but it is still percolating out there. I mean, we have declined to answer it in terms of giving out legal advice. There's no rule on it, so there hasn't been presented to the committee at this point.
That's understandable, but just at this point, I don't know where the branch is with their core operations bill. I know when I was in the legislature, it continued to morph all during the course of the legislative session. So I don't know if the administration would be amenable to including something like this, but it might be a quick fix that without giving legal advice, just let the legislature figure it out.
I suspect we could take it in and present it to Melissa, and she can determine whether or not it's something that can be attached.
That's what I'm thinking. Does that sound like a good next step, Denise?
I certainly will pass this along to Chris, but before I leave you today, is anyone doing anything wrong by swearing in? Should we not be doing it at all and having the lawyers do it? I just don't want to get in any trouble. I don't want to be doing the wrong thing and telling the association. I don't think you'll get in any trouble.
I don't think anybody's going to get into trouble. I don't think anybody's got an answer for you.
Okay. Okay.
Let's just cross our fingers and hope we can change the legislation.
Okay. All right. I just wanted to go back with something. So, okay. Thank you very much. I appreciate your time.
Thank you. Okay. The next item is 2022-020, proposal to amend practice book section 17-51. Related to summary judgment based on a defense that's only part of a claim, related to part of a claim. And my recollection is the last time we had this on our agenda, we had just gotten the letter from the Trial Lawyers Association, and I don't think any of us, in particular Judge Stewart, had an opportunity to review it and to digest its contents. So have you done anything since we last met, Judge Stewart, on that score? Have you talked to anybody or just considered it?
Yes, I did consider it some more, and I also had what I consider to be a fairly productive conversation with the principal author of the letter, Eleanor Sterling, who's at the Koskoff firm and who I've known for many years. And she volunteered herself. You may recall that at the last meeting on this subject of this group, you created a little subgroup, if you will, consisting of Judge Pearson, myself, a representative of the CTLA, the trial lawyers, and a representatives of the CDLA, the defense lawyers. As of Friday, I now have a volunteer from the defense lawyers, Jennifer Booker, who I believe is actually on this call today, and Eleanor volunteered herself. So we have a committee. And hopefully later today or tomorrow, I will be able to set up a Teams meeting or something of that nature of the four of us to have what I hope will be a more productive discussion of all the stakeholders to make some forward progress on this. And also, as probably was noted, I believe was noted on a revised agenda for today, the defense lawyers submitted their position on the rule.
Thank you. And I appreciate that legwork that you put in, both you and Judge Pearson. So we won't put this back onto our agenda until you tell Attorney Del Campo that we're ready to put it back on our agenda. Does that sound like, or administratively, the right way to proceed?
I think so. I should add, Attorney Del Campo was very helpful between the last meeting and this meeting. He got me, first of all, he discovered that the rule dates back to ancient history, and he could not locate any, for lack of a better term, legislative history on it, but he did provide and find for me the changes in 2013 that were made to the basic summary judgment rule to allow summary judgment on a defense. So Judge Pearson and I have that material, and I will, before we have this little subgroup meeting, I will make a little package up for the lawyers as well, so that they have the same information we have. But otherwise, yes, your proposal sounds fine. I'll let Attorney Del Campo know when we're ready to go with something.
Great. Any other comments from members of the committee before we move on about that issue? Okay. If not, the next item then is 2023-002, a proposal to amend MCLE rule section 2-27A to allow attorneys to earn up to 4 hours per year of credit by judging mock trials or moot courts at the undergraduate, high school, or middle school levels, in addition to those at the law school level. Our proposal has been sent to us, and we are graced by John Wiener, who's the Chief Justice's permanent law clerk, who I believe was involved in the development of this proposal. That's right. Come to the table, and we'd be happy to have any background about. I should also mention that we have, I don't know, was this distributed to everybody? Okay. We have two opinions that had been established in 2016 by the Commission on Minimum Continuing Legal Education, sort of blocking what this proposal is. So I would imagine that this proposal is in response to that, and to adjust the rules to allow for what was previously not allowed.
That's correct. And it's actually there was an intermediate response since 2016. So in 2019, the rules amended to allow attorneys to judge law school mock trial or law school moot court and receive CLE credit. Now it's 4 CLE credits. So we weren't part of that effort at that time. And we've had a lot of volunteers come to us and say, hey, can I have CLE credit for judging high school mock trial or undergraduate mock trial? And we looked at it and thought, no, that's a great idea. And it turns out New York, our neighboring state, offers credit for that as well. So we looked at the language. We did find those opinions, and our proposal would probably require the commission to go back and, I suppose, overrule those opinions. But we would just ask the committee to make the following change to subsection B7 of the MCLE rule, which is to insert scholastic, collegiate, or law school before the words moot court or mock trial competition. And the 4-hour limitation is an existing rule that's set forth in 227A(c)(1).
So let me ask, I mean, I read these opinions. They said it wasn't permitted because it wasn't allowed under the rule, basically. It didn't give any rationale for it.
Yeah.
I don't know if the members of the commission had any strong feeling of it, but have you heard from them or from anybody else about a rationale for why this wasn't allowed for high school or college mock trials?
I think at the time it was just the rule just didn't contemplate mock trials at all at that point. I think in 2019, when the rule was changed to allow law school, some language was adopted that appears to be from either Tennessee, Illinois, or state of Washington that only allows it for law schools. We looked at it, and our feeling is that judging the high school mock trials is actually equally as beneficial to the attorney as judging the law school mock trials. The rules of evidence are the same. We use a modified version of the Federal Rules of Evidence. Judges are required to make rulings, explain them to the students, explain them to the occasionally angry parents, and then provide a fair amount of critique to the students as well. One thing we've noticed with high school mock trials as compared to, say, some of the law school mock trials is if you volunteer for a high school mock trial, you're basically guaranteed to be making rulings. If you volunteer for the law school mock trials, you may be a scoring judge sitting in the jury box, not actually required to do much other than score and make some comments. And so our feeling is that volunteering for the high school mock trials is extremely valuable professional experience to all of the attorneys who are involved. Okay. And we included moot court as well. There are some high school and undergraduate moot court programs out there, and I would say that their materials are comparable to that of a 1L class.
I went on the judicial branch website, and this commission hasn't met since 2020. Do we know if it's still in existence?
I think it is. It stopped meeting during the pandemic, honestly. Now, but, of course, Judge Pizzuto has been elevated. Mike Bowler has retired. Judge Solomon is, I think, a senior judge or retired. We do have on the call, I think, Attorney Chris Slack, who is now the first assistant bar counsel in the statewide bar counsel's office. So I don't know if he has any historical information that he can add to the conversation. He wasn't on that, and he wasn't counsel at that point, but he may have some information from their files.
So we've lost video again. So if you're on Attorney Slack, please say anything you'd like to say that's germane to the subject.
Yes, thank you, Your Honor. I don't have anything to offer in terms of the background on this. What I would like to suggest is that the matter be tabled so that I could reach out to the Commission on MCLE to, in whatever the current format of it is, as Attorney Del Campo noted, I don't believe it's met since before the pandemic. But I would like the opportunity to reach out to them so that they could submit something in writing in response to the proposal here.
That's what we would normally do anyway. I don't think in the time I've been chairing this committee that we've ever taken something up and voted on it that month. We just are not that efficient. So we will do that. But as long as I've got you, is there anybody else? CBA?
Well, this is a CBA.
I know. I meant the section. Which section is this coming from?
Well, it started with the Civics Education Committee, then went to the House of Delegates, so it's been adopted as an association position.
Oh, okay. All right.
So there's
we
great
don't need,
enthusiasm for
I
it.
can't remember her name. She helps us out.
Melissa?
No. Not all of mine.
Marcy?
Marcy.
Yes.
Yeah. Yes, Marcy is generally our go-to on a lot of this stuff, but it's been approved by the whole House of Delegates. I think we can skip that point. So yes, we'll just table this for 1 month. Anybody, any other stakeholders, anybody can think should be solicited? Okay.
And we're of course happy to work with Attorney Slack and the commission to expedite this as well.
I appreciate that. All right. So that's the end of our agenda. The one thing I would like to revisit for a discussion, at least, brief discussion, is we had, before the current composition of the committee, there had been a suggestion by a member of the committee that's no longer a member of the committee that we resume in-person meetings at least a couple of times a year. I certainly don't mind. It's super convenient for me to do this, but it does take some effort with technology, setting up the room and so forth. We can do it if members of the committee want it. If it's more convenient for us just to meet on Teams, that's absolutely fine as well. I just thought I'd throw it open for a brief discussion. Judge Pratt, did you raise your hand?
Yes, please. Yeah, for me, Mondays are tough. It's like an arraignment court. I'm the one that does all the arraignments. So I have to say that being able to come on through Teams is very, very helpful. In most Mondays, I would not be able to make it at 2 if it would have to be in person. So I don't know.
Yep, I appreciate that. And I suspect Judge McLaughlin's not thrilled with the possibility of driving from Stanford to Hartford.
So I'm in Bridgeport, but yes, I'm similar to probably most of the judges. Just getting away on a Monday to drive up to Hartford is a bit of a challenge when you've got trials going, and certainly Mondays for me are trial days. So it would be, this has been a much more flexible and more I'll say inviting as far as being able to participate as often as possible. So I would prefer if we could at least, and I know some folks like to go up to Hartford, but if we could at least continue to do it in a hybrid manner. And I think we've been relatively effective on the teams. So
let me ask, is there anybody who wants to preserve the in-person option as a regular option? Any particular meeting that would require us to all gather? I guess we could just do it differently, but as an operating principle, does everybody just want to do Teams? Any opposition to just remaining on Teams? Gonna take silence as acquiescence. I would ask that we have that for the public hearing, that everybody be in Hartford for that, in case members of the public do want to actually show up here. They can do it by Teams, but for the public hearing, I think we should actually be assembled together.
Okay.
In May.
All right.
Other than that, we can continue with the monthly meetings as just on Teams. Is that okay with everyone? All right. Is there a motion to adjourn?
So moved.
Is there a second?
I'll second.
Second.
All in favor, say aye.
Aye.
Opposed, say
Aye.
no.
Aye.
That passes unanimously, and we will be adjourned. Thanks, everybody.